Hi, I'm Darcel Lobo, the owner and attorney of Dow Law Firm, and wanted to provide an overview for you today of the Chapter 7 bankruptcy process. A lot of times people have questions about how long it takes and what that process looks like, so I wanted to outline that for you today to answer some of those questions. Generally speaking, the rule of thumb is that the Chapter 7 bankruptcy takes about 90 days from start to finish. In reality, it's usually about 94 to 95 days from when you file. It's not exactly 90 days. So day one is when your case is filed. You're filing all of your petition documents, you completed your credit counseling course and you have that certificate, and you're paying the court's filing fee. All those items are filed with the court clerk for the bankruptcy court where you live. Usually about day 2 or day 3, after you filed, a bankruptcy trustee is assigned to your case and a 341 hearing is set. You may also hear this hearing referred to as a meeting of creditors. Notice of this meeting is mailed to all creditors in your bankruptcy schedule. So the ones that you've listed on your schedules, that is who will get notice of your bankruptcy. So it's very important that you have all of the creditors listed who you owe money to, so they will all get notice of your bankruptcy filing. The bankruptcy trustee who is assigned to your case, that is going to be the individual who's going to handle the administration of your bankruptcy case. In most cases, there are no assets to be administered, but this trustee is going to be the one who will administer those assets if there are any. Around day 30 from when your case is filed, you will have your 341 hearing or the meeting of creditors. About 7 days before that hearing, you have to provide what are called 4002 documents. That includes 60 days proof of income, bank statements, your recently filed tax return, and a declaration that you signed saying that all those documents are true and accurate. Those documents can be submitted to the trustee, usually online. They usually have a portal you can use to submit them, or they can be mailed directly to the trustee. If you have an attorney, he or she will handle that for you. At the 341 hearing, again, or the meeting of creditors, there's going to be about 10 questions that will be asked usually. Usually it's going to be your name, your address, did you read the documents? Was it accurate? Did you sign them? Did you list all of your assets? Did you list all of your debts? Do you owe anyone child support? Do you own any real estate? That's usually the questions that are asked if there's something unusual about your case. Maybe you have a pending personal injury claim. Maybe you have a claim for unpaid wages. If there's anything unusual that is not exempt, the trustee may ask questions about that, but your attorney will be there with you and should already have prepared you for those questions to expect. Your discharge will come about 60 days after the 341 hearing. Usually, again, about 64 to 65 days after that hearing. There is a 60-day deadline after the 341 hearing. That's why it cannot happen before those 60 days have passed. So usually around day 64, day 65, the case has been completed and your discharge will be entered. There is no hearing for the discharge. It is a court order that is entered by the judge appointed in your case, and they will mail a copy of the discharge directly to you, and your attorney will usually receive it in their email and they can forward it to you as well. The only hearing that you have to attend is the 341 hearing. There are no other hearings for you to attend. During your bankruptcy case, you have to also complete a second credit counseling course, usually known as a personal financial management course, that has to be completed during your bankruptcy case, and you will not receive your discharge until it has been completed. You cannot take it before your bankruptcy case. You must take it during the bankruptcy case. Once you have completed it and you have a certificate of proof, that needs to be filed with the court, and if you have an attorney, he or she will file that for you with the bankruptcy court. And this was an overview of the Chapter 7 bankruptcy process here in Washington State. If you have any questions about Chapter 7 bankruptcy, please give our office a call. We'd be happy to discuss that with you. We offer free consultations for our bankruptcy clients. So give us a call at 206-408-8158, and we'd be happy to assist you. Have a good day.